Ladies and gentlemen, welcome back to the Indie Zone. My name's Kathy. It is Friday the 18th of April, 103 days until voir dire in Idaho versus Kohberger, and it was a big day in terms of rulings that Judge Hippler has now memorialized to writing in the multiple motions in Limine that were filed back on the 21st and the 24th of February. Thereafter, there were responses and replies. Those are the briefings. Whoever files a motion, the other side has a due process right to be heard, and that's where the response, usually in opposition, is what we've seen with these in limine motions and the motions generally. And then the third step is the reply brief, where you saw whoever filed the original motion then had an opportunity to come back and have the last word in writing, not to re-argue the entire motion again, but to reply to the response. Then the last thing that happened was the marathon day of hearings on April 9th, 2025, when both sides came before Judge Stephen J. Hippler in his courtroom and made a last pitch to either grant their motions or deny the other side's motions. One of, I think, the important ones for the defense had to do with the state's motion in limine regarding alternative perpetrator evidence. This is essentially where a criminal defendant will raise, it's a defense, where an effort to raise reasonable doubt, they will point to someone else who's on the loose as being the correct defendant. But there's requirements. It's not enough to come up with a theory. It's not enough to say that you got the wrong person. The right person is out there somewhere in the world. There's requirements that must be produced to satisfy the rules of evidence and to get in front of the future jury who will serve in this case as the trier of fact. Judge Hippler is the trier of law. He makes the legal decisions, the decisions of law. The jury is the trier of fact, and as such, they will have the ultimate say as to whether or not Mr. Kohberger is not guilty or guilty of the 5 first-degree felonies that he is standing trial for in this capital case. They will make decisions on credibility of evidence, credibility of witnesses, how much weight to put. If, for example, there's a battle of the experts where one expert says that the DNA evidence on the sheath means this, while another expert says it means that, it's not Judge Hippler who's going to weigh which side to believe, which side to not believe. The alternative perpetrator theory that we're going to go over in just a minute and read what the court ruled and address what Mr. Kohberger is going to have to do to sustain his burden of bringing forward and this defense. What I wanted to begin with, because you're going to hear circumstantial evidence versus direct evidence in this defense of the alternative perpetrator, I want to look at IDJI 1.24.2. This is a standard jury instruction. This is on the Supreme Court of Idaho's website, where they have multiple jury instructions. And this is what, if Judge Hippler is going to use the standard jury instruction, he would be giving an instruction explaining what evidence is. IDJI 124.2 can be found if you follow this link to the Idaho Supreme Court. You can find a slew of standard criminal jury instructions, and it says here, evidence may be either direct or circumstantial. Direct evidence is evidence that directly proves a fact. Circumstantial evidence is evidence that indirectly proves the fact by proving one or more facts from which the fact at issue may be inferred. So with circumstantial evidence, there must be at least one inference that needs to be undertaken when considering this form of evidence. Next paragraph. The law makes no distinction between direct and circumstantial evidence as to the degree of proof required. Each is accepted as a reasonable method of proof, and each is respected for such convincing force as it may carry. This is why you may have sometimes heard that circumstantial evidence can sometimes be even more powerful than direct evidence. I believe that some people think that circumstantial evidence is of a less quality than direct evidence, but we see right here in this jury instruction that the law in Idaho makes no determination that one's better than the other or one's lesser than the other. What might be a simple example of what direct evidence is if, say, you were to be a testifying witness and the issue was it raining or not on Saturday, the 1st of May? If you look out your window on Saturday, the 1st of May, and see droplets of water, and you look up and it's coming from the sky, and the sky is dark and it's cloudy, and these droplets of water are coming down faster and faster, and it's making the street and the car wet, you've got direct evidence that it's raining or it rained on May 1st, a Saturday. What might be circumstantial evidence that you could create an inference about? Well, just say you look out the window and it's sunny outside, and you go and you take a nap, and it's Saturday, the 1st of May. And you wake up 2 hours later. You look outside, and the sky, whereas it was sunny, is dark. It's cloudy. It's overcast. It feels a little humid. And you see that your car that's parked out on the street is wet. The street's wet. You can make the circumstantial, the indirect inference that it rained while you were asleep. Let's go to the order memorializing oral rulings on motions in limine that Judge Hippler rendered today. Before the court are several motions in limine filed by both defendant and the state. Oral argument on motions was held on April 9th, 2025. On several motions, the court rendered oral rulings from the bench. This is sometimes called verbal rulings or verbal proclamations or oral proclamations from the bench, meaning he did not issue a written order that day, but he made a ruling verbally when he was at the bench during the hearing. This order serves to memorialize them, to memorialize those oral rulings together with the findings the court made during the hearing. So we see on page 1, the court provides the general standard regarding the relevancy of evidence. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence, citing to Idaho Rule of Evidence 401. Now, why is the court starting out with this? Because most of the motions in limine dealt with, in limine, that means before trial, rulings that the parties were seeking from Judge Hippler as to the admissibility or inadmissibility of evidence that would be brought before the trier of fact. And why this is so important is that the state bears the burden of proof at the evidentiary standard of beyond a reasonable doubt. State's motion in limine regarding alternative perpetrator evidence, and it says here that the state seeks an order prohibiting the defendant from offering alternative perpetrator evidence without first making a showing that such evidence is relevant and admissible under IRE 401 and 403. These are the rules governing evidence. These rules govern the standard of admissibility for alternate perpetrator evidence, citing to State versus Meister. This is an Idaho Supreme Court case from 2009. And here we see the court quoting, mere inferences that another person could have committed the crime will most likely not be relevant. And if relevant, will still be subject to the limitation provisions of Idaho Rule of Evidence 403. And the court notes here the defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to defendant, this case is, quote, full of alternate perpetrators, end of quote, and he intends to produce offers of proof as to alternate perpetrators. And then while the court says, while defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. And so what the court has ruled here is that the defense has to submit an offer of proof that will withstand the Meister ruling of admissibility of evidence. And now you know it can be circumstantial as well as direct, that there is an alternate perpetrator out there in order to raise reasonable doubt. And that's what the defense's job is to do. It's to raise reasonable doubt. And if there is reasonable doubt, the jury under the law is required to return not guilty verdicts in the case. So what the court said is at final pretrial conference, this matter will be addressed. Final pretrial conference is set by the court's October 9th pretrial and trial order. What the court ruled here is that by May 14th, which is the day before the pretrial conference, that Mr. Kohberger needs to bring forward offers of proof that this evidence is there to point to an alternative perpetrator, and this would give the state time to run down that whatever person or people that are offered up. And people have asked, do you have to give names? Yes, because it needs to, as we see from the Meister case, it just can't be, it could have been. And you need to have a person that's named as to who this other party is that the defense is raising. So we're going to look forward to the 14th of May, which is coming up in less than a month for this filing. It's probably going to be under seal. Not sure if that portion of the final pretrial conference will be open to the public or if it's going to be closed and sealed to the public, because they're talking about at this time who an alternative perpetrator is that is responsible for the catastrophic events that happened at 1122 King Road. So we'll wait for the filing. The May 15th hearing, even if it's just partially open to the public, I think is a really important hearing that if you're very interested in the case, that you should plan on watching if you're around and can do it during the day live or at least on replay, because this is the final pretrial conference and it's to prepare the case for trial, where voir dire is happening in 103 days. If you have any questions or comments, please leave them here. Until next time, my name's Kathy. I want to thank you for joining us here today.